went to general services today afterwards to see people, Debbie Hood came up to me and said, "Oh, I saw Christina today and we're so happy with her and I can just cry. I don't want to say anything more." So I know that many of you have seen her. I was at a pickleball court and Patty also mentioned about seeing Christina. So she's not a stranger to many of you, but like many of the people who come here talking to us about elder care and estate planning, she came to it the way many have, which is involvement with a family member who is not doing well. And her caregiving led her to get into social work, which there are a number of you who have done that. But then she realized there was another way to be very helpful, and she went to law school. So this is a dynamic duo of a person who knows the social aspects of it and who also knows the law to help. She's a member of many professional organizations. Like I said, she's taking care of many family members here. And so we're just so lucky that Christina has given up her afternoon and traveled all the way from downtown Houston to be here. Thanks, Christina.
Oh, thank you so much. Thank you. Before I get started, I just wanted to thank y'all for coming out, and I just wanted to say, what a good-looking group and well-dressed you are. When I was getting dressed this morning, I'm like, I'm going to put on a dress, just dress it up a little bit. And I'm glad I did, because y'all look amazing. And then I also want to thank Frankie, who also looks fantastic, and thank you for hosting this and helping me with the slides and doing all the technical things. It's just been an absolute pleasure to work with you on this project. And then I also wanted to identify any veterans or school teachers that are here in our audience today. Just thank you for your service. I actually brought one behind me. I have a veteran and a retired school teacher sitting back there. This is Penny Jones. Penny, would you wave? Okay. If you have any Texas history questions, she can answer them for you after our speech today. And I'll just a little bit more about me. I took care of my grandfather for several years, and then ended up working for an elder law attorney who said one day, you might be a better lawyer than a social worker. I said, I think I want to go to law school, because I definitely, as much as I love my social work practice, I really fell in love with the law and what it could do to help people and protect people. Because what I found out, it's not always that there's not laws or statutes or policies, is that people don't know that they're there to protect them. And I'm a firm believer in education as the daughter of retired school teachers, that our ability to navigate life becomes much better when we have information. So it's in that spirit that I'm going to go over a couple of things with you today. So that's just a little bit about me. There's a highly airbrushed picture of myself. So just we're on the same page. There's in order to establish an attorney-client relationship with myself, you have to sign a contract to come and see me. So just by hanging out with me today, there's no attorney-client relationship. So today we're going to talk about some important estate planning documents, some myths, and then we're going to get a little 2025 update. We're going to talk about medical documents. We're going to talk about wills and trusts. And many of you may already have a will or a trust. I just want to make sure that if you've got a will or a trust, that it says everything that you want it to say, and to make sure that your wishes are implemented. So most people, when I go and speak, have already signed some documents. It's interesting for me to see that people will go and get wills done, but then not get some of these other important documents. In fact, I think the most important document that we're going to talk about today is the durable power of attorney. Sometimes it's called the financial power of attorney. Sometimes it's called a business power of attorney. Is that better? Okay, someone said no. Okay. And what it does is it appoints somebody to handle your financial affairs, and it also appoints people to make business transactions for you. Now, anytime you're looking at a legal document, these are the things you want to know. Number one, what does it do? That's what it does, is it appoints somebody to handle your financial affairs. Number 2, when does it become effective? Now, the financial power of attorney, there's really 2 options. You can have it effective at signing, or what we call a springing power of attorney, meaning it's only usable when you become incapacitated. I'm going to tell you some personal family stories to illustrate what not to do, okay? So my dad, he's passed. He taught school for many years, and he taught humanities. And his expertise was Russian literature and Southern Gothic. And so when my dad was very ill and in the hospital, his wife was trying to use their financial power of attorney that was springing. And what that meant is she had to prove that he was incapacitated in order to use the document even though they were married. So if you have a financial power of attorney at home, what I want you to do when you go home tonight, here's your homework, is open up the document and see, when is it effective? Is it effective, or was it effective on the date that you signed that document, or is it considered springing? Meaning it's only going to be effective upon your incapacity. So back to the story, here's kind of the rub, here's the problem, is that my dad was very ill, but he was not incapacitated. But he was not able to make financial decisions for himself. So what had to happen? They had to go back to the lawyer. They lived in Wimberley. I don't know if you're familiar with Wimberley. It's like everything's far apart from each other, so the hospital was way on this side. And she did not need to be experiencing that extra layer of stress during a period of illness. Eventually, that new power of attorney was signed, and she was able to get into their checking account. So the moral of the story and my personal advice is that if you trust somebody to put on your document to handle your affairs when you're incapacitated, you should trust that same person when you do have capacity. So it's easier to use when you have a financial power of attorney that's effective immediately. If you don't trust somebody, then they shouldn't be on your financial power of attorney. Let's take a moment and think about who should be on your financial power of attorney. The little saying I have in my office is the 3 T's. They need to be talented, they need to be trustworthy, and they need to have time. And a lot of my clients struggle with putting adult children on their documents. What I explain to them is it is not a position of honor. Has anybody here served in the capacity as a financial power of attorney? Yeah, it's terrible. Did anybody have a good experience doing it? Did anybody enjoy it? No. Who wants to do their own finances besides somebody else? And then the other thing is that if your adult children are doing your finances, everybody else in the world is going to be judging and having commentary on what they're doing. So you really need to make sure that you have the right person. It may not be an adult child that's the right person. It may be a family friend. It may be something else. If you do that and you appoint people in the document in an order or in a manner that will be a surprise, we see this especially in second marriages, be sure you communicate that ahead of time. Otherwise, you may have a situation where litigation, people start fighting, then a bunch of lawyers get in a room, and things get real expensive quickly. So if you have a financial power of attorney, you're going to go home, you're going to look at it, you're going to see, okay, do I still like everybody named in this document? Because relationships change over time. People get ill, sometimes people get divorced, sometimes people just have personal things that pop up and they can't serve. I would even call your agents and say, hey, I just want to remind you that you're on my financial power of attorney. The other thing that you can do to make sure that you, what I call supercharge this document, is provide a copy to each financial institution, especially tax-deferred accounts or retirement accounts. Just because you are the beneficiary, or you've named a beneficiary on an account, that doesn't mean that they have management rights. So for example, my firm's care manager, Robert, who's sitting back there. Rob, you want to wave? I think you kind of stuck in at the back. So what Robert does is he helps people navigate the healthcare system, but he's also my brother. So what that means is I have an account set up for him. He's the beneficiary of that account, but that doesn't mean he has management during my lifetime. Retirement accounts, especially for spouses, you need to send in your financial power of attorney and make sure the legal department of that financial institution has approved it. The second thing that you're gonna do is you're gonna sign the financial institution's own power of attorney. So if you're at Chase Bank, Chase will have their own power of attorney and so forth. So we're really doing a belt and suspenders approach. Is this a little bit too much overkill and too many? Yes. But okay, this is what I forgot to tell you. When I have people ask questions, we're gonna take a vote. Do we wanna take his question, or are we gonna make him wait till the end of our presentation today? What do you want to do?
Wait.
Sorry, the people have spoken. The people have spoken. Mr. Weber, but you get to go first, okay? Okay, so make sure we have the power of attorney approved by each financial institution. By the way, on the financial powers of attorney, you don't necessarily have to have the original. A copy is usually good, except for real estate closings. So if you want to sell property, be sure your family knows where that original power of attorney is. Otherwise, they may have a problem. The point that we're doing here is that we are preparing documents, or we may be in a position where we are the agent. You want to make sure that you're giving your loved ones, your family, all the information they need to be successful. What a big job is it to manage somebody else's life. If you're asking somebody to do that, they need to have, or at least know where to locate the financial power of attorney. You need to have some type of information on where all your accounts are. You need to have some kind of information on what bills you're paying, so that they can do a good job. Okay, it's just not fair for us to not prepare them for that. Okay, so that's the financial power of attorney. The takeaway is make it effective, put the best people on the document, and make sure that each bank has a copy of the financial power of attorney. Now let's talk about the medical power of attorney. What does it do? It appoints somebody to make healthcare decisions for you when you cannot do that. When is it effective? Only at incapacity, okay? So another question I get is, do the people who are on the financial power of attorney also need to be on the medical power of attorney? And I'm gonna give you the lawyerly answer, which is, let's see if y'all know. It depends. It depends. I would not put in first place a financial power of attorney and then put someone on the medical power of attorney who don't like each other. If you have dueling siblings, they will fight, because do people act better or worse during times of illness or death? That's right. So we need to look at who we have handling the money, who we have making the medical decisions, and see if there's any conflicts of personalities. Because sometimes the things that come up about conflicts of personalities have nothing to do with present day events. It has to do with things and trauma and family disputes that happened 30 years ago. Okay, so that's your decision on the medical power of attorney. It's effective in incapacity. You need to put the people there that are going to do the best job. My brother is number one medical power of attorney, because I know he is calm in situations that are chaotic. And number two, he knows his way around the healthcare system. So that's why he is, by the way, did you know that you're number one on my medical power of attorney? Did I tell you that?
Number one everywhere.
Number one. Get the money and make all my decisions for me, please. So the other document that I'm gonna go down to is the HIPAA release, where you're gonna go back to the directive to physicians. Let's talk about the HIPAA release. Keep in mind the medical power of attorney is only effective if you become incapacitated. But what if you are not incapacitated, you're just in the hospital and you want people to call and check on you? You may want to have what we call a standalone HIPAA release that is a group of people that can access your medical information. So you may have people on your HIPAA release that you would never want to make a medical decision for you, but you just want them to be able to call and check on you. So the HIPAA release, what it does is it allows people access to your medical information. When is it effective? At signing, and lasts for 2 years after your date of death. Why do we have it 2 years after date of death? is because we want to be able to talk to insurance companies. Maybe there's a medical malpractice. There's all types of legal reasons we may need access to your medical records after death. Okay. We have next our directive to physicians, also known as the living will. Have you all familiar, are these terms sounding familiar, the living will? So what it does is it tells your family, your medical power of attorney, and your doctors what type of end-of-life treatment that do you want. Do you want to be have sustaining life, continued life-sustaining treatment, or do you want that withdrawn? Now, when I was in law school, this was a big topic, removal of life-sustaining treatment. This was right after the Terry Schiavo case. Do y'all remember the Terry Schiavo case? I know Frankie does. I'll give you just a quick memory. Terry Schiavo was a young woman living in Florida. She was married. She had some type of acute medical event. I think there were some information that she had an eating disorder. She ended up going into a coma, and it was a battle between her parents and her husband. Her parents were very religious and wanted to keep her on life-sustaining treatment. Her husband wanted to remove life-sustaining treatment. She had no written information on what she wanted to have done. So even though she was married, there is still a possibility of another family member coming in if there's nothing in writing on what you want to have done. Sometimes my clients will say, my kids know what I want. And I'm like, that is great. But you need to give them the confidence and the clarity when or if that happens to make these very difficult decisions. And I think probably there's a group of you here that have had to make these decisions for a parent, a spouse, a loved one. Rob and I and our family had to do it when our grandfather was passing, and luckily we were all on the same page. But you want to have this in writing. And the directive to physician, it applies to a very specific situation. You are incapacitated, it is end of life, which according to the Texas legislature means you have 6 months or less to live. And then you can decide if you want to continue life-sustaining treatment or remove life-sustaining treatment and die as gently as possible. As an attorney, it's not my job to tell you what to do, but it's for us to walk through what this means from a legal standpoint. Often I will have my clients have their medical professionals in their lives, sometimes a religious professional, sometimes just a friend, review the document with you. There's also in the document a little section that says additional requests. I've had all kinds of language in this additional request section that would say, before you remove life-sustaining treatment, I want last rites, or I would like this doctor to come and see me, or XYZ. It's very personal. Remember what it's like, if you've been in this situation, to have to make decisions quickly and under a large amount of stress. So the more directives we can give our families, the better. So then we have the do not resuscitate, which gets convoluted with the directive to physicians. What the do not resuscitate says is people that do not want to have CPR, advanced airway management, defibrillation, artificial vents, and cardiac pacing. So to me, that is a decision between my client and their doctor, but typically I see people who have had a lot of medical issues, are frail. They may be a good candidate to have that conversation with their doctor about a do not resuscitate. We see this out of hospital do not resuscitate. So if you were going to somebody's home and like there was like a sign on the door, and then there was like a sign on the refrigerator, and there was like a sign above the bed, and that's trying to communicate to the paramedics or whoever would come in, this person does not want to be resuscitated. Now we all know that things happen in life, and life is not perfect. So it's not a guarantee that if you have an out of hospital or in hospital DNR that those wishes will be followed. So be sure you tell everybody, then you tell everybody again, and then you tell everybody again. Okay, so that's what that document does. The last little thing I want y'all to put on your notes, you know, these days everybody has like a My Chart, right? Y'all do My Chart? Go ahead and load up that medical POA, that directive to physicians, and then that HIPAA release into your My Chart. That way, if you have an emergency surgery and you roll in, they go, do you have advanced directives? You can go, Absolutely, it's all on my chart. And I don't know if you've noticed this lately, but like, I go to MD Anderson and then I also go to Memorial Hermann, and their My Chart portals are interfaced. So be sure that you load those up. I know Kelsey Siebold has its own portal as well. Okay, so incapacity claims that we've been talking about. You're sick, or you're managing an estate, or you're managing finances or healthcare for another person. Make sure you have copies of the documents, that people know they're named, that the banks have copies, and that they're reviewed on a regular basis. So I like to pick like the 4th of July ish for me to review my documents to make sure that everything is in order. Okay, so that is our medical. So now we're gonna start talking about documents that distribute assets at your death. Before I go through the slides, I wanna tell you the one thing I want you to know about estate planning as far as after your death, what you need to know. And if y'all take this home, it'll make me so happy. Beneficiary designations, payable on death, joint tenants with right of survivorship are always gonna control over your will, okay? So if you have a beneficiary designation to an ex-spouse or to somebody you don't like anymore, you need to go back and check it. Because I have had more tears shed in my office because a parent did not update their beneficiary designations. It is so important. Ideally, how many engineers do we have here before I ask this question? I know there's at least, I know there's gonna be at least a half a dozen of y'all here. Engineers, build everybody an Excel spreadsheet. New project for Trace Talks. Actually, I have an Excel spreadsheet, so Frankie, if you'll do me a reminder email, I have even got one built for you. And in that Excel spreadsheet, it's gonna say all your assets are. It's gonna have a column that says, how is it controlled? Is it my trust? Is it my financial power of attorney? Beneficiary designation update. So you've got a dashboard for your stuff. And I will be happy to supply this to y'all, and then you fill it out and you send it to your family. Or if you are acting as financial power of attorney for somebody else, you need to fill this out and know. And I will tell you, engineers, it's missing a couple of things like the bills that need to be paid. So if someone wants to update the data collection in the Excel spreadsheet and send it back to me, that would be amazing. I'll give you mine, we can work together on this. It's so important to get it done. And then most of our adult children, they're not wanting paper these days, right? The saddest cases I have is like the adult kids come into my office, it's like a Kroger bag full of documents, and then they're like, I have no idea what mom had. Here's the will. And they're just like tearing. Like I had a offshore, what do they call the guys that work offshore? They're real big. You know what I'm talking about? Roughneck, like from Urban Cowboy. Come into my office, and he's just a big guy, and tears just streaming down his face because his mother had just passed away, and he's not used to working with financial accounts. He's got a big stack of documents and her original will. He goes, what do I do? I'm like, oh man, like the mom, I know this guy's like my age, but my mama heart in me was just breaking for him. So we want to do better. Okay, we want to be able to communicate and be able to share information to our loved ones. So let's talk about how we are going to be able to give money to people when we die. So the first thing we're going to do is a will. Here's the good thing about Texas. And does everybody consider themselves residents of Harris County? Anybody here consider themselves a resident of Brazoria County? Good, that's the right answer. In Harris County, if your estate planning is will-based, it's so easy we don't have to go to court anymore. We go to a Zoom hearing. Or we have one judge that makes you go to the lawyer's office. So you come to my office or your lawyer's office, you get a cup of coffee, you get some candy, we hang out for a little bit, then we prep you. It takes about 1 to 2 minutes. And then the judge is on a big TV screen like this. And then we have like a 1-minute hearing, and then you go home. It's not like the old days where you had to go down, find a parking spot. Did anybody probate downtown before COVID? Good times. And you were in that old Harris County building with like the juvenile docket and everybody that had, got in trouble for something else over family law over the weekend. So it's so much easier now. So a will, if you have a will-based plan, that is not necessarily a bad plan. It's super easy. What a will does is it says, hey, anything that doesn't have a beneficiary designation, joint tenants with right of survivorship, payable on death, the will's going to control. But for the will to pass the property to your family, you have to go to probate. It does not happen automatically. But probate in Texas has gotten a lot better, and in Harris County it's gotten a lot better. The amount of pleadings and paperwork and stuff has gone from this much to like this much. And that's since I've been practicing, okay? Then, what you need to know is that an executor, they have to be appointed, meaning they have to come to an office of a lawyer, they have to take an oath, they have to be appointed. Just having the will and dying is not enough. Sorry. That was funny. I didn't mean it to be funny, but that was kind of funny. Thank you. So in order to probate, you have to do it within 4 years as of the date of death. So a lot of times families will come in my office, like their loved one died like last week. And I'm like, no, it's too early. Y'all, my personal experience is that you need 30 days from the date of death. I mean, you need to write the thank you notes. You gotta like get stuff organized. You're just kind of dealing with shock. So wait 30 days. But the original will, you've got 4 years from the date of death to present it. So it's not, a lot of people are in a big hurry. They don't need to be in a big hurry. If it's been more than 4 years, we can still probate it if we have a really, really good reason. Like, oh, we thought everything passed by payable on death, and then we didn't know that mom had this weird lot out in Montgomery County when no one knew about it. Probably the judge is gonna be okay. You have to have the original will. Sometimes a copy of a will can be probated. I probated a lot of copies because of all the floods. So a lot of people had their documents drenched, and then they were all covered with mold, and so we just probated copies of them. So again, the executor, like the financial power of attorney, you need to make sure they have time, they have talent, and they're trustworthy. And because of our ability to zoom in, I've got an executor that lives in Japan. I have another gentleman who is an executor of his dad's estate, and he lives in San Francisco. So we are not locked in like we were 20 years ago, and it has to be somebody local. So that's not needed. Not needed for the financial power of attorney either. Really, getting the right person at the right time or to do the right job is what we need. So you know if you have a beneficiary designation on something, that is going to control over the will, right? Does everybody know that? All right. I will tell you, I lose sleep over beneficiary designations at my office. Okay, again, we have a slide. The beneficiary designation will trump the will. It must be reviewed carefully. So you know that spreadsheet that we're making with all the engineers that I'm going to send Frankie? This is a good way for you to track. Okay, I've got my life insurance, beneficiary designation's been updated. Any retired school teachers here? Don't forget, or your ERS people, don't forget you've got your $10,000 death benefit. Do not forget that. Don't name somebody there that you don't like anymore. The other thing we want to be careful about beneficiary designations is if we're designating it to a minor grandchild, we don't want to do that. A trust should usually be set up, or to a person with a disability who may be receiving Social Security disability benefits or Medicaid benefits. So be aware of the particulars of who's receiving it. So I have a medically fragile nephew, and I want to make sure that when I die, my beneficiary designation of this one insurance policy I have is going to go to a trust for him, so that it doesn't disqualify him for Social Security or Medicaid, and he's a minor. So know what's going on with your beneficiaries, your family. A lot of times people don't want to talk about it. I've had a lot of clients come in and they'll say, well, I've got an adult daughter, she's got a son, we think he may be on the spectrum. They're kind of shy about it, there's been no diagnosis. We need to have conversations around that. Okay, so we have a trust. And I get a lot of questions about, should I have a will? Should I have a trust? Susie Orman says I need a trust. My neighbor from church says I need a will. right? They're both right, okay? Because it's going to depend on what your particular needs are. A trust is a legal instrument that will typically have assets funded or transferred to it during your lifetime, and then that trust acts as the instrument if you become sick. If you have out-of-state property, especially in California, Louisiana, New York State, or Florida, or you have a mineral or gas interest in any state, you probably want a trust because it makes the distribution at your death easier. So if you die a Texas resident and you've got a lot in Florida, your family will have to do what's called an ancillary probate, meaning they'll get to enjoy probate in Harris County and in Florida where your lot is. And let me tell you what my experience is. These out-of-state properties are never high dollar value. It's usually like mom bought this lot in Arizona. They were going to build, it was going to be like a club or something, and then nothing ever happened. She passed away, and then now we've got a $5,000 piece of property in Arizona, and the legal fees are $10,000. That's how it usually works. So do everybody a favor. Get rid of it. That's what I did. I had a lot. I'm from Huntsville. I had a lot there with big dreams. I was going to build a house, and then I just sold it because I was just like, yeah, it's not going to happen. So a truster is going to depend on what's going on with you particular. But if you have a trust, which I explain in my office, it's like a cereal bowl. We put stuff in it during your lifetime. Then the trustee or the person in charge of that cereal bowl, usually you first and then your family or whoever is going to act second, they're in charge after you. But I will tell you, probate in Texas has gotten a lot easier, but sometimes you really need a trust. And by the way, even if you have a trust, you gotta have a will. Because sometimes we don't get everything pointed to the will. Pointed into the trust, and we have to have something called a pour over, like you're pouring over. So if you have this trust, you've done all this good planning, and you inherit this lot right before you pass away, and your family's still gonna have to go to probate. I'm telling you, undeveloped lots have caused more problems in my practice than I could shake a stick at. So you don't have to raise your hand if you have a lot somewhere. But just know that lot that you inherited that's in Connecticut from your great grandma years ago, and you're like, it's not worth anything, I don't need to do anything. Yes, you do. Yes, you do. You need to take care of it. Okay. We talked about wills, we talked about trust, personal items. What I love about my Eagles Trace clients and family is the simple act of y'all moving here probably made y'all downsize a bunch, right? Did everybody have to get rid of stuff? Did anybody just move into Eagles Trace like, yeah, Did anybody not have to like get rid of stuff? Yeah, we have one in the front row. Yeah, I'm definitely gonna have to get rid of stuff. I find myself buying the same shirt over and over again. Okay, so personal items. You've probably already done a great job decreasing the amount of stuff that you own, but if you have a personal item, best thing is to give it away during your lifetime. If you've got jewelry, make sure people know where it goes. Appointment for agent for remains. And again, most of my Eagles Trace folks, because you guys are kind of a different breed. You're planners, you're forward thinkers. That's why you're here. But just if you don't have it done, get your pre-need funeral arrangements done. Have a document that says what kind of funeral you would want, so people are not left guessing. If you come from a certain religious background and you want a hymn, I'm thinking for anybody here Catholic, on Eagles Wings, yeah, Eagles Wings, that was a real popular one during the 80s and 90s, okay. And then we have a special or supplemental needs trust. If you're thinking about giving anything to a family member that is on Medicaid or Social Security, or that should be, I don't know if anybody is familiar with like an adult son or daughter that never quite launched, or has a family member that never quite launched. Sometimes they didn't launch because they may have some kind of undiagnosed something going on there, and they really may need to qualify for benefits. You don't want to make them ineligible financially. You could always leave assets to them in a special or supplemental needs trust, even if they have not received or have applied for those benefits yet. Okay. Number one, we all know that a will avoids probate, right? Right? Non-probate assets, you can do that by trust funding, beneficiary designations, and transfer on death deeds. Also, we can use ladybird deeds. So basically now in Texas, you can make everything, including real property, totally outside of the probate estate. So transfer on death deed, ladybird deed, acts like a beneficiary designation on a piece of real property. They're a beautiful thing and we use them all the time. Okay, once I sign my documents, I'm done. Sign at the lawyer's office, never have to see that lady again, go on my little life. No. I would suggest going to see an attorney every 2 to 3 years, or if there's a major life event. I would say at least on your own, check yearly. Because when I have clients come in to review their documents, this is always what happens. I don't remember putting her on my medical power of attorney. How'd she get on there? I'm like, well, I don't know her, so you told me to put the document name there. Oh, this lady moved away. Or this person's passed away. And it's like this shock, because we forget what arrangements, which is fine, but you just need to take a look at it every year and make sure that you are still happy with the people that you have listed in your documents. And let me just go back. I probably should have started out with this. Why do we do all this powers of attorney, will, trust? Why are we doing all this? In other words, what happens if, let's say you just said, I don't want to worry about it, I'm not gonna do anything. And then you become incapacitated. Don't worry, the law has a solution for that. It's called guardianship. Anybody here get to enjoy guardianship? No? Guardianship is when you are alive and you cannot handle your financial or medical decisions because of some type of illness. And then what happens is your family and friends have to go to court and pay a lot of money to a lawyer to become your guardian of your person or guardian of your estate. And so when that happens, your funds pay for all those legal fees. Okay? So you don't want that. So let's say you die without a will. Guess what happens? The law has that taken care of too. We have little pie charts and little flow charts. All my engineers, y'all would love this. It's like married, no kids, this is what happens. And so a lot of people who have second marriages are very upset when their parents are on that second or third marriage and they find out that the community property goes to the second or third wife and not to them because their dad died without a will. So that's why we do it. So we want to review our estate planning documents. We want to avoid all those legal problems. Probate's always a nightmare. No, it's not perfect. It takes a while sometimes, but it's not bad. In Texas, especially Harris County, we've got a nice group of judges. We have a 5th probate judge. They are they're working hard, especially Judge Semino, who is kind of the head judge, on making sure that he's making it more efficient. And he believes in what we call an open court, meaning he wants the court system available to everybody, even people that can't go down to the court physically because of health issues. He wants you to be able to participate. So if you ever don't have a lot to do, or if you're taking your lunch break like I am, I watch probate hearings. It's just interesting to me. Okay. Out of state, real estate isn't a big deal. Remember we talked about that ancillary probate. We can avoid having a probate in 2 different states, either with a trust or a deed. I don't need a financial power of attorney. I'm married. We all know that's wrong, right? It doesn't matter how long you've been married. Being a beneficiary does not count. Oh, this is my favorite. Ms. Lesher, I downloaded, and I don't have a beef against Susie Orman. I love her. And in fact, I'm going to call in and see if I can afford something. Did you ever watch that show? Just me? Okay. The generic forms are often, that people find online, done incorrectly, not executed correctly. They often are leaving out important elements to make the will valid. So, a judge I used to work for used to say, Lesher, the law's gonna let you take out your own appendix, but why would you want to? So, A power of attorney gives my agent power after I die. The financial power of attorney, when you die, it dies. And then that's when the will comes up. And remember what we have to do with the will is we have to go get you appointed as the executor. If you have a trust, we don't have to do that. Okay. Estate planning is only about death. As we've discussed today, a solid plan also addresses your incapacity. To me, death is a lot less scarier than incapacity. At death, all the unknowns are known. We know what happened to you. We know how much you're going to cost. Done. But when you're incapacitated, that's when we have issues because it's a longer period of time. I've had clients that have lived with some type of incapacity or disability of 20, 30, 40 years. It's a long period of time. Okay. My spouse will already get everything. We talked about that. You know, we need to be careful, especially if we have second or third marriages. You need to have a will. I don't like being the bearer of bad news, but I've had to be the bearer of bad news of people who have come in my office and their parent did not have a will, and the house that they were living in ended up going to the surviving spouse and not them. If you have a will from another state, it's automatically valid? No. What's usually missing is what we call the self-proving affidavit, which takes the testimony of the witnesses that you were over the age of 18 and of sound mind when you signed that will. Okay, so common mistakes, not updating your agents, and not putting backup agents. So I see a lot of people, they'll have one person, they'll just have the spouse. And I'm like, well, what happens if the spouse dies? Well, I didn't think about that. Make sure you've got at least, I would say, 2 to 3. And then not giving your agent instructions on how to access your accounts and your bills. Because when somebody's your financial power of attorney, they have what we call a fiduciary responsibility. Meaning if they don't do a good job, they can get in civil and criminal trouble. So you don't want that. Okay, we want everybody to do the right thing. We talked about beneficiary designations, disabled spouse, family members, blended families. If you were in a second or third marriage, is that my phone? Okay, that's okay. I just want to make sure it wasn't me. So if you were in a second or third marriage, my advice to you is make sure when you die, your biological children get something. The personal items and some type of cash, usually by beneficiary designation would be good. So if this is your second or third marriage and you've got a life insurance policy or like an investment account, maybe give that to the kids so that they feel like they get something. Do it for family harmony and do it because when that surviving spouse dies, your kids may not get anything else. Okay, so it's been an interesting year as far as the news. Has anybody been following the news lately? Okay. So I want to talk about a little bit about the One Big Beautiful Bill Act and some of the tax reforms that were signed in over the summer. There are different types of taxes. Now, when you die and you inherit property or you're gifted property, there's no tax. How when someone dies, there may be a death or an estate tax, and that's what we're going to talk about now. So for right now, per person, when you die, you get to exempt or not count 13.99 million, which is going to go up to 15 million in 2026. And by the way, when the first spouse dies, there's never an estate or death tax, okay? Sometimes when we start increasing the amount of exemption for estate tax, sometimes people want to start making more gifts. So if you are high net worth, you may want to start thinking about making gifts to children or charities. And then one thing I want to just talk about for these donor advised funds, these are called DAFs. And you don't have to have $13 million to do this. Like you could just be like me, like a regular person and have a donor advised fund. So let's say you have a charity in the Houston area that you love. So you know, Houston is a very charitable city. And there's big charities like the Alzheimer's Association, and then there's little charities like the Arbor School that I'm involved with for medically fragile children. It's a little tiny school, and it fills in the gaps of what public benefits provides. And so I'm not sure that the Arbor School is always gonna be there. So I could do a DAF that says, hey, I want everything to go to the Arbor School, but if the Arbor School is not around, then I want this nonprofit, or you can have it go through like a Fidelity will do this, then I want them to pick a school of similar nature, and then they take care of that. And then the gift to Fidelity is a charitable gift. So if you are a charitable-minded person and you're interested in making gifts with a lot of flexibility, you may want to take a look at a donor advised fund. And if you're banking at or investing at Schwab, Fidelity, most of the places where you already have your brokerage accounts will have these donor advised funds. Talk to your financial advisor; they'll be happy to talk to you about it. But it's a pretty neat way to make gifts. And if that charity is not available at the time of your death, then they'll find somebody. Okay, digital assets. Just know that one of the biggest pains is to try to get somebody's password. All right? So in our Excel spreadsheet, are all the engineers taking notes on our improvements for the Excel spreadsheet? I'm looking at this guy because he's like, so we need the bills, and then we also need to know digital assets. So we want to make sure that if you've got cryptocurrency, your social media password, if you're on Facebook, make those arrangements. We spend time trying to get into people's accounts. Okay. So what you might want to do is just make sure if your estate's, I would say if your estate is over 20 million, you probably need to go back and see an estate planning attorney. You need to make sure that you've got your digital assets under control, that you have some way for your family and loved ones to get into your accounts. We're using this term called a trust protector. Now, if you are bored by this presentation at this point, this is where you can check out. But if you're kind of a nerd like me and you really like to get down to the nitty-gritty of stuff, this is cool. What a trust protector is going to do is it's language you can put in your estate planning documents that says, hey, if something changes after I become incapacitated or I die, I want this person to be able to change my trust after I've died or after I've become incapacitated in order to update my document with those changes. Obviously, this needs to be a person that you have a lot of confidence in. But if you have like an adult daughter or son that's a CPA or lawyer, they are able to change your documents so we don't have to go to court. It saves money, it saves time, and it keeps the decision making within the family. I would say stay alert for future tax law shifts. This usually happens at the end of the year, so usually between Christmas and the first of the year is when they like to vote on things because everybody's asleep. And then review things on a regular schedule. If you spend time in another state, be sure you've got a medical power of attorney for that state. And then here's some resources. Let me tell you what I think is the best resource on there. And that is the elder law attorneys. You can find any elder law attorney. There's a whole, I'm not the only one. But what I like about NALA is that they are going to give you up-to-date information on Medicare. Is the government shutdown going to affect your Social Security deposits? What options, if you're on a Medicare Advantage, what does that mean? What about the donut hole? What's happening on a legislative basis, broadly, on a federal level that is going to impact you? It's free, nonpartisan information that is available to the public. If you are a veteran or the wife of a veteran, please check out what benefits you're going to have there, and then we've got some other information here. Okay, I'm going to give you, do I have room for like one more thing?
Oh, yeah.
Okay. I learned something this week, and I'm pretty excited about it. So, I've been practicing for 22 years, and I learn something new every day. And my philosophy is, I want to be a better lawyer today than I was yesterday, and tomorrow I'm going to be a better lawyer than I am today. So I learned, and my biggest source of learning is a lot of times from clients. What I learned this week is that there, and if y'all do LinkedIn, are y'all familiar with LinkedIn? If you go to my LinkedIn page, there is an article, and it's called the No Surprises Act. Are y'all familiar with this? I didn't know about this. So here's what happens. You go to the hospital, and you think everybody in the hospital is covered under your insurance. Not always. There might be a contract person that's not under your insurance, and all of a sudden you get a bill for that medical provider. It's gonna look at that article, and it's gonna show you how to defend yourself against those surprise bills, okay? Also on LinkedIn is something that's called observation status. Is anybody familiar with Medicare observation status? The front row says yes. So let's say you go to the hospital, you're in a hospital bed, you're checked in, you think, hey, I'm checked in, right? I'm inpatient. No. You have to be very diligent, your family has to be very diligent that you are admitted. If you're not a full admit, then there's no Medicare covered rehab, even if you've been there for 3 nights. Okay, because everybody, most of y'all know, you go to the hospital, you stay for 3 nights, you might be eligible for rehab for up to maybe 100 days. Wrong.
If the doctor prescribes rehabilitation.
Thank you. Thank you. So my brother says if the doctor prescribes rehabilitation. Okay, so let's say you're at the rehab, and the doctor says to you about a friend, or maybe you're not improving, so sorry. Have y'all heard that? That is not the law, it never has been. So go into my LinkedIn page, there's gonna be a whole article on there, and there's a lawsuit that's called Hemo versus Sibelius. And basically in the CMS regs, it says if rehab is medically necessary, then they may have up to 100 days. And there's actually a link to a self-help packet in that LinkedIn article, okay? So be an advocate, plan, and then go have fun, right? Be an advocate, plan, and go have fun. Okay, Frankie, how much time do I have for questions?
We have 10, 15 minutes.
All right.
Okay,
Oh, yeah.
she really doesn't want me to
do my questions. There we go. And I have about 10 or 15 minutes worth of questions that I've been accumulating while you've been talking. No, honestly, just 2, because you really covered most of my questions. The first has to do with power of attorney, and honestly, virtually everything else. If you designate somebody as a power of attorney, do they have to accept that responsibility?
No.
How do you affirm that, okay, I designated, my daughter to be, my power of attorney, and she says, screw you, I don't want that.
Well, probably asking her ahead of time would be the best.
You think?
And a lot of people don't ask. And then I would make sure that you have, because someone could say yes and mean it with their whole heart, but then have something happen to them and then not be able to do it. So I would have a couple of people after that, just in case it happens.
Okay. The other question, and this actually applies to everybody in this room. Every single person in here has a beneficiary designation, because when you signed your residence and care agreement, on the last page of the residence and care agreement, it designates how your entrance deposit is to be distributed if you leave.
I'm familiar with the document.
Yeah.
Yeah.
So I suggest, this has come up a couple of times, I suggest everybody in this room go back and take a look at their copy and make sure that what it says on the residence and care agreement is really what you want to do.
Yeah, don't forget, I think that's such a great point, these little things like the deposit where it may have been a long time ago, or maybe a life insurance policy you have through work. That's very smart. So, but for everybody, go back and check your Eagles Trace information and make sure it says what you wanted to
Yeah,
know.
it specifies 3 options. Option 1 is a specifically designated
The fund.
beneficiary.
Okay.
Option 2 is a trust. Option 3 is to your state.
Yeah, yeah.
But it's specifies you have to pick one of those
Yeah.
three.
Yeah, that's a great reminder. Okay, any other questions? Yes?
Okay, what?
Yes.
Okay. What can you tell me about a DNI? I'm familiar with the DNR, but my son's ran into a situation with a friend whose parents, something happened. They had the DNR, so
Mhm.
they could not be resuscitated.
Mhm.
The DNI is do not intubate.
Intubate. Yeah.
It is listed, on Google and on the internet, but I could not find any form.
I don't think there's a statutory form for it. There may be Google forms for other states, but I don't believe that there's a statutory form for that. But Rob, I'll have Rob do a little check here while we're all together.
Is there, way to ensure that you are not intubated?
I think the best thing would be under the directive to physicians. It does, if you look at the directive to physicians, there is language about intubation. But other states, was it a different state? Was it a different state? No, interesting. Does anybody know the answer to this question? Rob does, Rob?
It says it's included in your out-of-hospital DNR form.
Yeah, it's in your out-of-hospital DNR, but it's also in the directive to physicians as well. Okay. Yes. Sherilyn.
Horror story with my mother. She did have a power of attorney assigned. She never notified him. She had been his client maybe 20 years before. He didn't even remember her. And all of a sudden, we're calling him and saying, we need you to exercise your power of attorney. And he's going, say what? So very kindly, he was a real gentleman, and he did do it, and he didn't even charge her for a long time.
Yeah.
But I will say this, when you get into the problems of guardianships, we wound up having 3 attorneys covering my mother's care.
That sounds about right.
Yeah, one for her person, well, 2 for her person,
Yep.
one representing her family, another one representing some friends of hers.
Yep.
And then the financial power of attorney. So beware.
You mentioned about putting a lot of information on my chart. I now have 9 of them. Because what's happened is as the individual doctors have gotten into this idea, each of them now sets up a my chart for you.
Oh my God.
So does that mean I need to go through and put that same information on all 9 of them?
Yeah.
What if they're different?
What if they're different, what? Different my charts?
Oh, what if they say different things?
Then I guess you're going to do that. You can't get it off. That's what, I don't know. That sounds like an IT issue that's out of my pay grade.
Yeah, but it's getting very difficult.
Yeah,
because-
I would maybe reach out to a patient advocate and maybe see if they have a recommendation.
Thank you.
But your other thing too is just to make sure that your agents have your medical powers of attorney electronically, because it doesn't have to be the hard copy. Yeah.
Okay, I have a question. Here.
Okay, hold on just a second.
Okay, because,
Guess what?
well, no, I very often see people jumping up out of line.
Oh, okay. I'll get you next, and you're right here. I just have to stay here because Frankie said I have to stay here.
Okay.
She said you have to stay in this little square, so that's what I'm doing now. It's nothing personal,
Okay, no,
but I'm listening.
yeah, this didn't really involve you. I have 2 questions. One involves a joint account, and the other is any advantage in putting an annuity into a trust. So at the joint account, you were saying this problem, let's say, are you advising, or is it advisable for, say, a husband and wife to have joint accounts? Because if one passes away, the other one then has complete access, say, to a bank account, checking account, etc.
Usually,
Yeah, okay.
it depends on the marriage.
Yeah. Okay. So, and then the other part of my question is, if you have, one of the things that people think, and insurance agents usually say this, is you have an annuity, the beneficiaries love them because the annuities
Yeah.
get transferred very easily.
Mhm.
But is there any advantage in addition putting an annuity into a trust, or a disadvantage in doing that?
I don't think you can.
You usually don't, we can't put annuities into a trust. Yeah, you don't want to put an annuity into a trust for tax purposes. He's next, I promise.
He's next, right.
And
Then him, and then.
But, so what you would do to address the incapacity is just make sure that the financial power of attorneys with the insurance company, your beneficiary designation is updated. And I would just even say, you name the people and then, percentages, and then your final beneficiary, you might want to put as your estate or your trust, and then that would control in case your beneficiaries pass away before you. But yeah, I usually for tax purposes, I just have never seen an account that bad tax things didn't happen with an annuity if we put it into a trust. Yeah. Yes, sir.
How much does an attorney charge in order to do all this wonderful stuff?
So I charge a consultation fee that's an hour, it's $5.95, and then I charge a flat fee for all work after that. And that flat or one fee depends on the amount of work that needs to be done, but everything is put in writing, so you know how much you're gonna spend with me. And I'm not gonna give you an estimate.
Does that include that you would probate?
No, it doesn't include
Separate
probate, yeah, probate would be a separate charge, yeah. Most lawyers, I don't like to pay for something that I can't guarantee that I'm gonna be around for, because I can get hit by a bus, and that would be not good for you.
How do you get to your LinkedIn page? I never heard of LinkedIn.
LinkedIn, all you do is you would just Google, Google, would you Google?
You're not talking to a computer genius.
Okay.
We'll get you after.
I'll get you. I'll get you after. Who else? Okay, Frank, you take it.
Well, he was next.
Who's next?
Here.
Yes, that $5,000 mountain property that you own in Florida, can you just refuse to accept that as part of the state?
It depends on that state's what we call disclaimable laws. In Texas, we follow the federal statute, which is you have 9 months to disclaim a piece of property. So do it quickly. Sometimes though, the other thing you could do, like say you have like and here's the other rub to that. It's a $5,000 piece of property, and the property taxes that are under $10,000. I would call the county and just say, I'm gonna give it to you guys. And they have lawyers that can handle that. Yeah. Okay. Frankie said, hold on, I'm following Frankie's lead.
Yeah.
So,
I have a
yes.
question here.
Yes.
Thank you for coming to share this
thank
all
you.
information. First is, could you share your presentation with us? Is it possible?
Absolutely.
Okay.
Frankie can,
Frankie.
she's got it.
PDF, I'll send it.
Thank you. And the other thing is, I want to find out whether you also, in your practice, assisting clients to build their trust. Because
Yes.
I keep hearing
Yes.
more on the will and probate. Another question on the probate, is it still true that even in Harris County, if we go through the will, the probate, we're still gonna get, I guess, certain percentage fee for?
No, can I repeat that question? Because that's a common myth. That's a good myth. In some states, like California, the lawyers are entitled to a percentage of the estate. Good news for y'all, Texas is not one of those. What happens if I probate an estate? I'll look at the estate, we look at the complexity, and then we give you a fee. Yeah, but the lawyers are not entitled to a percentage.
Now, last question about beneficiary. If the beneficiary is not, between the spouse, but other than the spouse, and the beneficiary is in a foreign country aboard, when the death occurs, would that name or that someone would track down where the beneficiary is?
Yeah, this is a great question. What if you have an out-of-country beneficiary? The problem with having there's a bunch of problems. Not that you shouldn't do it, but there's problems. Number one, you should provide your attorney that information of that beneficiary's contact information as well as the financial institution. Number three, sometimes the financial institution, before they hand over the money, they want a social security number. Well, maybe you are somewhere you don't have a social security number. And the other thing is a tax issue. So it's not just the U.S. tax laws, it's what are the taxes in that foreign jurisdiction. I had a client whose mother passed away, she lived in Germany, and she got to pay a whopping 35%.
Wow.
There was really not a lot we could do about it. Yeah. Okay, Frankie? Yeah.
One other really quick question.
I mean, living trust?
Hold a second, I think we've gone on, I'm so sorry.
I didn't hear your answer on living trust.
Oh, okay, Frankie Living Fitch on Living Trust, sorry. Yes, we do help people do what I call fund their trust, meaning either by deed or by other documentation with the financial institution, transfer that asset to the name of the trust. No, we do, thank you. Okay.
One other real straightforward question. What if you happen to own a timeshare that you can't get rid of? And if you say, I'll die and just let it go, it goes to your kids, and your kids then have to pay all the taxes and the fees on it. How do you deal with that?
Well, I would tell the kids to disclaim that interest as soon as possible. And then I'd call timeshares and say, we're not paying. We're not paying. Sorry. You can either take back the interest or take us to court. What's going to be cheaper? We're not paying. There are some companies that will try to negotiate with you, but typically if I just tell them, hey, we're not paying, they'll usually go away, but I can't guarantee that. But yeah, and don't do it. If you have a timeshare, get rid of it now, please.
So you said we should review our wills. If you find minor things you need, is a codicil enough? How often do you need?
Yeah, that's such a good question. And this is my personal opinion, it's not law. I'm okay with one codicil, and then after that you need a new will. Because then it's just like, okay, is it this codicil, is it that codicil, da, 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 da. It becomes arduous. So I would say one codicil. And you cannot amend a will by handwriting it too, by the way. Sorry, you cannot amend a legal document by scratching. I see lots of people get mad and then scratch out people's names. Sorry, it's ineffective. It's interesting. I'm kind of gossiping. Okay.
Well.
That's it? Oh, so sweet. One last little thing. I want to thank my team, Robert, for coming out, and Miss Ireland, who was the hostess with the mostest, and Penny put together all the treats and all the stuff. So if you enjoyed that, that is Miss Penny, who is a retired school teacher. I hired her away from the school system, and now she works in my office and is also my travel buddy. So Texas history questions, school questions, Rob can help you. If you've got Rob is our resource at our office, and if you're in the hospital or a loved one's in the hospital and you feel like you need a patient advocate that's not with the hospital, Robert can help you do that. I hope that our time together went well for you, that you got something out of it. And thank you, Frankie. Look how beautiful and sparkly you are. Rob, you can get a picture of me and Miss Frankie, please. Okay, I'm going to take this mic off, so y'all have a good day.